Property disclosures, the real estate professional's guide to reducing risk. Page 4. Seller had held liable for failure to disclose raw sewage problem. Century 21, page 1 Realty versus Naghad. 760 SW2D 305 Tex 8 App 1988. The sellers listed their property with the real estate company. The neighbor informed the agent of the problem with raw sewage leaking onto the property and threatened to sue if the property was sold without first being repaired. The agent ignored the warning and sold the property. Soon after moving in, raw sewage leaked into the yard. The Texas Court of Appeals affirmed judgment against both the real estate agent and the seller for failing to disclose the problem. Negligent misrepresentation. Negligent misrepresentation imposes liability for false statements the real estate agent did not know were false but should have known were false. Negligent misrepresentation also involves the failure to confirm, when necessary, the accuracy of information provided by the seller or a lack of care in accurately conveying information to the purchaser. Negligent misrepresentation does not involve an intent to deceive. Disclaimer protects broker from misrepresentation claims. Hamtil versus J.C. Nichols Real Estate 22 Can App 809 923 P2D 513 Can CT App 1996. In 1996, Kansas case had a very favorable outcome for real estate practitioners, holding that they may protect themselves from negligent misrepresentation actions by disclaiming knowledge of the property's defects and having the seller acknowledge such disclaimer. The seller's disclosure statement asserted that they were not aware of any water leakage or damage, and the purchaser's inspectors found no significant problems. Immediately after closing, however, the purchaser discovered water damage throughout the house and sued all parties involved. The court ruled in favor of the licensees and noted that the purchasers had signed an acknowledgement that they weren't relying on any representations made by the licensees. The purchasers also had inspected the property several times, had chosen to rely on the property inspector they had hired, and had sought an attorney's advice before signing the agreement. Negligent non-disclosure. Negligent non-disclosure imposes liability for failure to exercise adequate care to discover a material defect and disclose it to the buyer. Courts have imposed the duty on real estate professionals to conduct a reasonably competent and diligent inspection of the property and to disclose to the buyer anything that would affect the value or desirability of the property. New Mexico and California are two states that recognize this legal theory of liability.